Okay, well, welcome to our monthly webinar. This month's topic is legal essentials for co-founders and business partners, and we'll be running through a lot of content around those topics for today. For those of you who don't know anything about Sprintlaw, a bit of a summary as to who we are. We're an online law firm really designed to make legal services easy, affordable, accessible for startups and small businesses. We offer fixed fee legal services for those of you that want to work with lawyers. We don't charge by the hour. We'll always give you a quote, and we operate in all the different areas of law that businesses may need help with, everything from helping you set up your business to intellectual property protection, employment law, data and privacy, contracts, and so on. We also have an optional membership subscription. About 90% of our clients sign up to it, and there's also a free tier if people just want to give it a spin and check it out. And it's got a ton of features, and we're adding a lot every week as well. You can make your own free legal documents. If you're a subscriber, you can get free quick consults with our lawyers. There's credits for legal advice, a legal health monitor, which is about to get a big upgrade and will help tell you what you need rather than you needing to figure it out for yourself. E-signatures tools sort of like DocuSign, and then our Tailor AI that gives you instant answers to legal questions and now allows you to upload documents as well to have them checked. So if you haven't checked that out already, I encourage you to just head over to our website and you should be able to sign up for a free account. A bit more about us. We've been around for about 8 years now, won lots of industry awards, lots of happy clients, growing internationally, and have a happy team. And we'd love to work with you if we don't already. And if off the back of this presentation, you do have more questions about co-founder issues, shareholder questions, maybe there's documents you need drafted, do feel free to book a free consult. I'll show this QR code at the end. We'll also drop a link in the chat, and you can reach out to our team. And we're doing some discounts at the moment for these sorts of related services if you mentioned that you attended the webinar. So let's get into the content for today. We're going to be talking about a bunch of different issues for those of you who are doing business with business partners or co-founders, or thinking of setting up a business with business partners and co-founders. We'll first cover the business structure, how to set up the business if you have another person involved in the founding, if you have a business partner involved. We'll then go into the key agreement that you would usually make with your business partners or co-founders, your shareholders or partnership agreement. We'll talk about what's included in those agreements, how they work, what are the different things you might need to work through, and I guess go through all the different key clauses, things like decision making, how decisions are made, how non-competes might work, termination, what happens if there's a dispute. And then at the end, we'll touch on a few other agreements that you may need as well to put in place, again, if you're doing business with other people. As I'm going through, we've got a Q&A feature in Zoom. Do feel free to drop questions in. I will try and leave a little bit of time at the end if we have some time, but equally, I enjoy answering the questions while we're on the slides because I think it helps add some color to what we're talking about. So if you think of questions along the way, do feel free to just drop them and I'll keep an eye on the Q&A. I see we've already got one from Sonia. Yes, we will have a recording of this webinar, which I think will be on YouTube in our member platform, and we usually email it out as well to everyone, so you should be able to access it. So let's start by talking about business structures. If you're going into business with somebody else, one of the first questions you need to figure out is how are we going to set things up? Now, there is a few different structures that you can choose to operate a business in Australia. The simplest structures you can choose are setting up as a sole trader, which is sort of like a one-person business. It's just sort of you running a business, and you would go register an ABN, Australian Business Number, and you can sort of use that as your number to operate your business activities. Obviously, that works for one person, but if you are working with other people, at minimum, you're going to need a structure that supports more than one person. So on the right of this screen, we have something called a partnership structure. And this is when two or more people can sort of set up a business together as partners. And again, you can go register an ABN, Australian Business Number, for a partnership, get a tax file number, and then sort of go out and do business together. Now, these structures are sole trader and partnership. These structures are simple structures, but they don't involve setting up a sort of legal entity that exists separate from the people in it. And I'll talk a little bit more about what I mean by that in a moment. But in essence, if you set up using a sole trader or a partnership structure, if something goes wrong in the business, the law doesn't really see that much of a difference between the business and you personally as, the business partner or the individual. So if you own things like, your house, your car, whatever other assets you have, if you're operating under these structures, um, they all could be liable if there's an issue with a customer or an employee of, for example, your partnership. If they decide to sort of sue you for something going wrong, you can't say, oh, that's just a business problem. It doesn't affect me personally. That separation doesn't exist with these structures. And so you can already see that we as lawyers don't really love these structures. We'd like to protect people from risk. So while they're simple, easy to set up, they're not really what we recommend for most people doing business. These structures, the company structures, are the more common structures that we recommend for people doing business with others. And these involve setting up a separate legal entity from the people that are involved in setting up the business. And what do I mean by that? A separate legal entity you can almost think of as a separate legal person to the people that set it up. That legal person will have a name. It might have its own bank account. It can potentially enter into contracts with people, sign documents, employ people. And it is a sort of separate legal person from the people that set it up. It doesn't have a arms or a mind, but it has these things called directors or shareholders. And directors are sort of like the mind and the arms of the company. They can sign off on contracts as if they were the company. They can operate the bank account as if they were the company. And then the people that own that legal entity are sort of the shareholders. Are kind of like the body of that fictional legal person. So you can think of this thing as a separate entity from you as individuals. And the big consequence of that, the reason it matters, is because if something goes wrong in the company structure, the business partners behind it are generally, with some exceptions, protected from personal liability. So your company might get sued, it might get into trouble, something might go wrong. The liability of your company is limited to that company. If somebody tries to sue the company, the business partners or founders' assets are generally protected. Your house would be fine even if the company collapses. I say generally, there are exceptions if you're breaching what we call directors' duties in the way that you set up the company. There's maybe fraud that's happening, or you're not honestly running the company. And there's a bunch of exceptions to that sort of a general principle. But in general terms, one of the big advantages of the company structure is that you have this limited liability protection. And I see we have a question from Simi there about what do you mean by not a legal entity. So hopefully that sort of answers that. So you can see on screen, we've got a few different company structures. Now, the most simple company structure, if you're doing business with someone else, is just to set up a single company. And that company is the fictional legal person. It'll have its own bank account. It will start to employ people. It'll sign contracts with your lease or your customers or whatever contracts you might enter into. It'll sign up to your software subscriptions, your Microsoft Word or your Google Drive or whatever it is. And it will sort of run the business, and it will be owned by the business partners, and in some percentage. So we have these things called shares, which specify the ownership of the company. So maybe there's two founders; they each own 50% of the company, and that might be how it's set up. Maybe the company takes on investors who put in some money; they own 10%, and then the founders own 45% each. And you can sort of start to slice the pie again when you have these company structures. And that's kind of how things are set up. And separate from the people that own the company, as I mentioned, you have the directors of the company. So the owners are called sort of the shareholders, the people that might own the 50%, the 45%, whatever it is. And the directors, as I mentioned earlier, are those that can actually control the company and its day-to-day decisions it makes to enter contracts and so on. Usually when you first get set up, the people that own the company and the directors are the same. But over time, it might be that you take on investors and other people that own a piece of the company, but you don't really want them, signing off on what goes into the bank account and how money moves and so on. So it's a subset of those owners that sort of are the directors. And there's many different ways to set things up. But yeah, so conceptually, they're two different sort of roles, but early on, they're often the same in companies. In the middle, we have the dual company structure. This is a little more sophisticated, but again, lawyers like this structure even more. You can see we now have two companies at play. We have a holding company and an operating company. And so why would you do this? Well, I mentioned earlier, one of the big advantages of the company is you set up this separate legal person, almost like a bucket that can, hold the bank account, hold the cash, employ people, enter into contracts. If something goes wrong, the liability is limited to that company and it can't sort of go through to these business partners behind the scenes. But if your company starts to actually itself have valuable things, maybe it starts to actually have some serious cash, a lot of the cash that matters to you. Maybe it has intellectual property that's really important. Maybe there's software and other sort of valuable assets. So even though the liability is limited over here in this single company structure to the company, you might want even more protection from the company's key assets. So what you can do is you can set up this holding company, and the holding company would potentially have all of your key assets, your cash, your IP, almost like a safety deposit box. And then it owns another company, which is your operating company. And that's the one that goes out and enters into contracts and hires people. And the advantage of this structure is if something goes wrong down at the operating company level, there's a dispute with the customer, there's a dispute with, an employee or whatever it is, the operating company may be liable, but a lot of your key assets could be held in another company, and the liability would be limited in these cases of disputes to the operating company, and the holding company may be safe. So you can actually protect some of your company key assets by splitting the structure into a multi-company structure. And over time, larger businesses end up with, a tree structure where maybe they've got their Australian company and their UK company and, their company that just does one type of service. And what you're doing essentially is you're siloing the risk of your business into these different company buckets. So if something goes wrong somewhere, it doesn't affect everyone else, if that makes sense. So hopefully you're starting to get a flavor for why we use the company structures in these contexts. But on the right, we have an even more sophisticated structure, and this is closer to the gold standard structure that lawyers would recommend people who are doing business with others consider. And what you have here is you still got your holding company, you've got your operating company. Right up at the top, though, you've got extra sort of personal companies, trust companies for the founders themselves. And so you can see in the structures on the left half of the screen, whilst the founders are protected from issues with, clients or employees who probably could only come after the company, if there's a dispute up here between the founders, there's not really a company sitting between them. If there's a dispute around, the share ownership or what might have happened in the setting up of the business, the founders, if they own the shares sort of personally, they own their stakes personally, might still have legal liability to each other as individuals. So you can see on the right here, by having personal companies for the founders, they provide another layer of protection from other founders and potentially investors for things that may go wrong in the business. So you can see here, Founder One is quite well protected. Founder One has a company shield against all the other owners. They then got their holding company and the operating company, and you've got to kind of get through a fortress to actually hold Founder One liable for anything. So it does involve having multiple companies, and we'll talk a little bit about the pros and cons of these structures in a moment. But this is one of the reasons that things are set up this way. The reason that you use this thing called a trust company rather than a normal company is there's often tax advantages to holding your shares in a holding company through a trust. Whether there is or not depends on your personal situation, but often for founders there is. And it can be in the way that you issue dividends to yourself that may flow from the company. So this often we suggest our clients consider getting tax advice as to whether they should use a trust company to hold their own stake in their company. But again, usually it does end up making sense. And so to give the example of Sprintlaw, we have a structure sort of like the one on the right. I'm one of the founders. I have a trust that owns my stake in Sprintlaw Group, Pty Ltd. We then have Sprintlaw Australia, Sprintlaw UK, and a couple of other companies that operate various parts of our business. And so, we're kind of operating this structure. So that gives you a bit of a flavor for how things can work. But that said, a lot of our clients stick with the ones on the left and right. They don't want to go through the headache of having to maintain so many companies. You need to do tax returns for each of them. So there's advantages and disadvantages. I've got on this screen a little bit of a comparison table to show you if you're trying to figure out how your company should be set up, or if you've already got a setup, what it might want to evolve to, the pros and cons of each of these models. You can see the sole trader We think it's quite risky. Lots of personal liability, can't raise investment for the business. Um, if the business ends, it can't really be sold to someone else because it's sort of held by the individual, and tax is all done personally. So the main advantage is that it's cheap, but it's not great for control liability capital raising purposes. And then over to the other end, we have the trust structure that I just showed, which has really good liability protection. It's great for raising investment. It can be the company can still be sold quite easily. You'll have these tax advantages, but it's the most expensive because essentially you're going to need to do tax returns for every one of those companies and register multiple companies. And you can see the company in the middle, just a single company, is often a nice middle ground of having that control, that liability protection. But it's not quite as good or flexible as those dual company and hybrid structures. So hopefully you're getting a little bit of a feel for how this stuff kind of works. So that's on the company structures. Now let's talk about if you've got your company or business set up with one or more business partners, what do you need to do? What do you need to put in place to make sure that everybody's protected and things can run smoothly? Well, the number one sort of key document that most lawyers would recommend that you put in place is a shareholders agreement. Now, I say shareholders or partnership agreement because if you choose the partnership structure, there's not really any shares at play. So the equivalent contract is just called a partnership agreement. But for those of you who have been convinced by sort of what I was describing before to set up the company structure, most of you would end up with the shareholders agreement version of this. It might be colloquially called a business partnership agreement. You might hear people call it that. But in legal terms, it's called a shareholders agreement because it's an agreement between the owners or shareholders of the company. And these documents set out a lot of different important matters. They cover what are the different rights and obligations of each of the company owners, what happens if there's a dispute in terms of how the company should be operated, what happens if someone owns more than others, if we've got majority and minority shareholders, how do we make sure that everyone's rights are balanced? What happens if third parties want to come in, someone wants to bring in third parties into the business, how does that work? And what happens if there's an issue with one of the shareholders, somebody leaves, maybe they get ill, they can't operate in the business anymore, how might the business continue in those circumstances? These are all important matters. Of course, as soon as you start doing business with other people, you need to start thinking about, what happens if circumstances change from where they are right now. And even in really positive relationships, things change over time. And it's really important to set the ground rules early on in the business as to what will happen as things change. And we often find that having the shareholders agreement in place from the beginning actually gives all of the business partners a really solid foundation and confidence in the way the relationship works. Many of the shareholders disputes that we see or business partner fallouts we see is often because some of these little details had never been discussed, and when they're first raised, when they become an issue, everyone has a different idea of how they should be dealt with. There's no rule book, and unnecessary little disputes escalate into a bigger fallout. So they really can provide a very important role, and they're not a compulsory legal document. You don't need a shareholders agreement or a partnership agreement, but they are very, very highly recommended. And again, we suggest nearly 100% of people with more than one person involved in a company do these agreements. So what is in these agreements? Well, there's a bunch of different concepts that they cover. They're quite long documents. They cover, first of all, decision-making processes, vesting schedules, which we'll talk about in a moment, in terms of like what happens if people leave sort of early on, drag along and tag along rights, which we'll cover in terms of when majority and minority shareholders might want different things in various scenarios, termination, how might this agreement end or be edited, rights of refusal. This is to protect third parties coming in and diluting the stake of certain owners, dividends, how does money get issued out of the business, dispute resolution, what happens if there's an argument between the different business partners, and then non-compete clauses. How do we stop people who are in the business from sort of leaving and just setting up another business that does the same thing? David's asked the question, isn't the company constitution also a shareholders agreement? That's a good question. No, they're different documents. So the company constitution is a document that, again, is also not required by law, but every company has some basic rule book that will determine sort of how decisions themselves are made in practical terms, like what kind of document needs to be issued to confirm that the company has made a decision. And under the Corporations Act, when you set up a company, you don't need this constitution document, but if you don't have one, the Corporations Act itself will give you a bunch of what we call replaceable rules or template rules that will be in force for the company. Because if you just set up the company but there's no guidance anywhere in terms of how decisions are made, well, then you wouldn't really know if something had been done by the company or not done by the company. So the Constitution is a procedural document. Again, usually if people set up a company with a lawyer or accountant or using an online service, you'll just receive a template constitution. In the 20, 30 years ago, in sort of late 21st century, constitutions were used a lot to cover a lot of the stuff I just mentioned, these kinds of clauses. And so you have these really long and complicated constitutions. They would cover practical matters like how decisions were made, and recorded in, for example, resolutions. But they would also cover these more subjective matters in terms of how all of this stuff should work. Over time, it's become common practice to leave the Constitution as a fairly standard document, which has, again, more procedural points around how to run a meeting, how to record a decision in writing. But in terms of the more subjective matters, what percentage approval do we need to pass a decision? What should happen if there's a dispute, et cetera, et cetera? Every company wants to do those things differently. It's become more common to do them outside of the Constitution and in this document called a shareholders agreement, in part because the Constitution, because it's a kind of regulated document, there's laws around how it can be edited, how it can be changed, and it actually lacks flexibility in the way that it can be managed. And it has enshrined in it an ability for majorities to just edit it without minority approval. So because it's kind of an inflexible document, it's not great for handling all of the different scenarios that you might end up in, wanting to negotiate with your business partners around these different topics. So again, it's become common practice to have this fairly template constitution that you might have got when you set up the company, but actually have all the conversations and record in writing the details of the running of the business in these shareholders agreements. So hopefully that makes sense. And again, a lot of people think, oh no, I've sorted this out. We got a constitution. You probably haven't sorted a lot of this stuff out. You're just relying on a sort of template. Also, I can see a question here from Sonia about family business. I might cover that at the end because that will cover a few different aspects. So let's go through each of these clauses in detail, and we'll start with the decision-making processes. So in these shareholders agreements, there's a section of the document around decision-making, and it's a section that talks about how key decisions about the company are made. So in general, for a company to make a decision, as I mentioned earlier, there are these people called directors. You need a director to sort of sign off on a document. If you've got more than one director, two directors, or more, you need two directors to sign off on it, or a director and a company secretary, which is a role that you can set up when you form the company, which is a person that might have some authority to make decisions or sign off on things, but doesn't actually have that full decision-making power. But in essence, the default position is for a company to make a decision, the directors have to approve the decision. If it's a sort of a contract they're entering into, they need to need to sign the document. And if it's just a decision in terms of an action of the company, you would issue a resolution to say the company's doing this. Now, on a day-to-day basis, every little decision doesn't need to go to the directors of the company to sort of sign off on the document approving that an email will be sent or that that a decision will be made. And often what you'll do in these documents is you'll set out that, look, the company will have a CEO or a manager or someone running the day-to-day, and they have what we call delegated authority to make all the different day-to-day decisions of the company. But these critical key decisions need to come to the board or to the company directors to formally approve because they're really important decisions. And that's what you're putting in the shareholders agreement. You're listing these critical decisions that someone can't just go off and make without checking with others, but actually need to be formally considered and approved. And that might be approving a budget for what you're going to spend for the year. That might be the decision to sell the business. That might be the decision to replace an executive. That might be a decision to change what the business fundamentally does. That might be a decision to raise investment. That might be a decision to increase the salaries of key executives to a certain level. These kinds of key decisions is what you're going to put in the shareholders agreement. You're going to say day-to-day decisions can be made by the executive teams and others, but these key decisions cannot be made without checking with the directors. You may also say, because as I said earlier, there's a difference between directors and shareholders. If you've got investors or people that are owning a percentage of the business without being a director in charge of these big decisions, you might have another set of decisions that are even bigger stakes that need to actually go to your shareholders as well. So your shareholders agreement will often have two sections that'll say these decisions need to be made by a majority of directors, and these decisions need to be made by a majority of shareholders. And the really critical stuff will often go in the shareholders one, like the decision to sell the business or change what the business does. And the more operational decisions, like how much are we going to spend in the next 6 months, employment contract changes and those sorts of things, will just be handled by the directors. Early in your business journey, as I said, if it's just a couple of people setting up a business, you're likely to both be the shareholders and the directors. So, what goes in each bucket doesn't matter as much. But as your business grows, you have more people making decisions each day. And even if there's one or more of you, having clarity around what one needs to check with the other becomes really important. So at least having agreed what the big things are in this document makes a big difference. And if you work with us or really any lawyers, we will help you understand what the common ways of handling decision-making processes are and the kinds of things that need to go in here, so you don't have to think of it all yourself. We've got a good set of lists that are commonly used, but there may be specific things specific to your business that you just want to make sure can't be done without everyone agreeing, if that makes sense. So really important is the decision-making section of your shareholders agreement. The next section we are going to cover, we have on the right, is the right of refusal. So this is the right for existing shareholders to have the first opportunity to buy any new shares that may be issued by the company. So what do we mean by this? A company may begin with a couple of people owning, let's say, 50-50 of a business. Over time, you may bring on investors in the business who will put in some money into the business, who might own, let's say, 10% of the business, and then that would change the mix of the business. So the investors might own 10%, and the two founders I mentioned earlier would each own, let's say, 45%. Let's say the founders who are running the company decide they want to take on even more investment. What they would then likely do is go out and find some potentially new investors. Of course, they could use their existing investor, but they may find some new investors who they want to bring into the company, and sell a piece of the company to these new investors. For the existing investors, they may not like that. They may not want other people coming into the party without themselves having the opportunity to invest first, because if they allow other people to come into the company or join the party, then those other people might dilute their stake. Their 10% might become 8% or 7% if other investors or people are coming in. So usually in a shareholders agreement, you'll have a concept of right of refusal, which allows existing shareholders to have the first look at any capital raising activity or any sale of shares that happens in the company. Before we can bring in new shareholders, we've got to check, why are we doing this, and can existing shareholders come in instead? And so, you often have this thing called a right of first refusal. And that right of first refusal might apply not only to, raising new investment for the business, but may also apply to a sale. If a co-founder, wants to sell some of their 45% stake, they can't just sell it for a really good price to some other person that existing 10% shareholder will say, well, why don't I get to buy it for that really good price? I was here first. Why are you bringing in someone else to dilute me for such a good price? So again, it's elevation for the existing shareholders that in general, they will have the first opportunity to buy shares, and it protects them from being diluted when the company is offering new shares or potentially selling shares. So this is an important concept. And again, it sounds, you can see from sort of the different scenarios that might play out, the control of the company being dispersed or diluted if all these new people are coming in without a proper process for agreement around that. So that's why this is a fairly important concept in your shareholders agreements. Next, we'll talk about vesting schedules. So vesting is a sort of legal term that we use to describe a timeline for people to earn their shares. And so oftentimes it's used, for example, with founders to encourage them to stay involved in a company long term. You may set up a business with a business partner and you may say, okay, it's a 50-50 split of this company. But what happens after a year if one of the founders says, I don't want to do this anymore, and they leave? And the other founder wants to keep going, keep the company running, and build it into something bigger and longer lasting. The first founder may be a little annoyed that the second founder was involved in the business for just a tiny period of time, but then for the rest of its life, own half the company. So oftentimes you'll agree to a vesting schedule. You may say, for example, we're 50-50 to begin with, but if one of us leaves within the first 4 years, we're going to lose some of our shares. And you might stage it over time. You might say, if either of us leaves in the first year, we lose everything. After year one, if we stay between 1 to 2 years, our 50 will go down to, let's say, 15%. If we stay for 2 years, our 50 will go down to, let's say, 35%. 3 years, it'll go down to 40%. If we stay for a full 4 years and then we leave, we get to keep that 50% forever. So that's often how you will set up a structure, and it protects each party from if one leaves early. It may also be used with employees or advisors who you give a little bit of an ownership stake in the company to. Again, you can insert vesting schedules in case they leave early. They're a very useful tool for making sure that if someone's getting a stake, they actually stay long enough to earn that stake. We see this inserted a lot actually by investors. A lot of founders will set up the company not wanting to agree to this. They want their stake from day one, but oftentimes venture capital or other investors who come into a business will say, I'm happy to put in, $100,000, $200,000, $1 million into this company. But if somebody leaves, pretty quickly, we want them to lose their equity stake because we're paying for their next few years of work and delivering on whatever you've promised. So a very important concept and included in a lot of shareholders agreements. On the right, we have dividends. So what happens if the company is producing a profit? How does it get split between the different owners? Well, usually this whole concept of 50%, 45%, 30% will determine how much of the profits of a company get distributed to the owners. If you own 50%, you may be entitled to 50% of the profits of the company. If you own 10%, it may be 10%. However, it's often not that simple in the way that the business wants to run. If the business is making some profit, it may be that what's best for the company is not to pay that out to the owners, but actually to reinvest it back into the business. Oftentimes for startup companies, there is no profit for many years, and they are taking on investment to really grow the business. So dividends may not be issued for companies to the owners at all or very much, but you want to have in your shareholders agreement a process for deciding how dividends work. Now, it could be very flexible and simple, and it may just say, the board of directors will decide once a year whether they're going to issue any dividend or no dividend, and they'll choose whatever the amount should be based on how much they think should go back in the company and how much should go to shareholders. It may say that. Or it may say, it's agreed that 30% of the company profit will be issued to the shareholders and 70% will go back in the business. And this will happen once a quarter or once a year. There's many different ways to set out a dividend policy, but this is the document where it can live. And again, it can be agreed by everyone who's coming into the business how it works. And then it can be quite clear how the money is going to flow out of the business. And if you don't have something like this, can obviously imagine there's big disputes about what should happen with the company money and who should be in charge of making the decision as to who gets what. So again, something to think about, and there's different structures that we commonly recommend uh, around how to set that up. Now let's get to the drag along and tag along clauses. These are clauses that you find in shareholders agreements which deal with the difference in dynamic between majority and minority shareholders. And they're all about what happens if someone wants to buy the company. Now, without these clauses, what could happen is, let's say you got a company with a few people that together own 70% of the company, and a few people that together own 30% of the company, and the 70% group decide to sell out their shares to a big company who wants to buy a lot of the business. The majority shareholders already have all the decision-making power. They can control the business. They can vote on all the decisions. They can, because of the way the shareholders may be structured, they can maybe approve everything they need. And so the person buying it thinks, well, I don't need to buy out those minority shareholders. I can just buy out the majority shareholders for a little bit cheaper, and I can control the whole business anyway. For the minority shareholders, if this happens, you're left behind. No one wants to buy your shares because you have no real power in the business, and all the majorities get the joy of selling the company while you're sort of left behind. So the drag along clause the tag along clause rather is in the scenario I just described, will allow the minority shareholders to forcibly tag along if there's a sale at any one time of a majority of the business. So it might say if more than 70% or more of the company is going to be sold to a third-party buyer, the minorities have the right, they don't have to, but they have the right to tag along and force the buyer to buy all of the shares of the company. So you can see in this scenario, it protects the minorities from being left behind. They can tag along with the majority. The drag along clause is the inverse. What if the majority wants to sell the shares to a buyer, but 2% shareholder decides they don't want to sell unless you give them more money? They hold out and go, I'm not selling because you need me, so why don't you pay me 3 times as much? And they can ruin the whole deal by holding out. So again, for the majority, if you need to get 100% approval all the time, it can cause those kinds of issues. So you often want in your shareholders agreement a drag along clause that says if there's a minority owner of the company or minority business partner, they can't block the sale of the company. If we get 70% saying yes, we can force the remaining 30 to come across. So again, these are some of the scenarios that happen when you have multiple people involved in a business, and these clauses help specify what those percentages are, and that may depend on what you want to do for your business, and then what happens in the various cases. So really important clauses. Then on the right, we have the dispute resolution clause. Again, another really critical sort of section of your business partner agreement. What happens if there's a falling out between business partners? What happens if a decision can't be agreed, or there's a feeling that one business partner did something that the other business partner didn't like? How are these disagreements going to be handled? Well, what you often want to avoid is there being no process for handling these disputes and it just ending up in court with people suing each other about various scenarios. So usually you'll have a dispute resolution section of your shareholders agreement that will talk a little bit about what needs to happen before anyone can go to court. And often what needs to happen is the parties need to meet and try and resolve it in good faith. If they can't, they may be required to go to a mediation type service, and the mediators will attempt to, in a low-cost fashion, resolve the dispute, come to some kind of compromise. It may include an arbitration, which is an alternative to going to court, where a third-party expert is appointed to resolve the issue. And it may, if there is an irresolvable dispute or a decision that can't be reached, specify that a majority shareholder might then, if things can't be resolved, have the right to buy out the minority shareholder at some agreed price. So having a procedure for dispute resolution, there's many different ones that people decide to put in place in business partnerships, really can take the wind out of any disputes that otherwise may blow up. And we see, again, people that have a proper dispute resolution clause, very few of them end up in court when there's a dispute with business partners. Some kind of resolution is reached and tons of money is saved because they have a proper process. Either they're able to work it out when they're forced to sit down together, or if they can't work it out that way, a third party who's an expert dispute resolver can help come to a compromise and resolve any of the disagreements. So strongly recommended to have these clauses in place. And again, you can start to see some of the benefits of them. And then finally, the last two clauses we'll cover are the termination and the non-compete clauses. So how do shareholders agreements end is a big question. Well, the termination clause will set that out, and it may naturally end when the company is sold or the company goes insolvent. But also, it might need to be edited from time to time if new investors are coming in or new business partners are coming in, or you just want to change the way that the company's run. So again, you want to have a procedure for how that works, exactly what's going to happen. What happens to any dividends that hadn't been paid out at the time of the agreement ending? What happens if new investors are coming in and the agreement needs to be changed? Who needs to agree to it? It's a really important thing to set out. And again, if you don't have that in writing, it can be very unclear how the terms can change. So definitely a clause that you want to be having in there. And then we've got the non-compete clause. And this is, again, something that we get a lot of questions about. What's to stop my business partner going off, leaving me behind, and stealing all of the ideas and setting up another business? Well, in general, you've got things like intellectual property protection and confidentiality protections, which often are also in the shareholders agreement, which you could use to stop business partners from going and stealing stuff. But it can be difficult to prove if they go off and start a competitive business that they have actually stolen specific things. So a more general non-compete clause is usually recommended, and it basically stops business partners from leaving the business and creating a competitive business for a period of time. And the non-compete clause under law can't last forever, but it can last for a reasonable period of time. It can define exactly what they can and can't do if they leave. And again, there's often a discussion around whether it's like an industry-wide non-compete or specific to the sort of business that you're operating. And again, if you have investors or other forms of sort of financial business partners coming in, they might insist on this because they're putting their money in this particular company, and they want to make sure that the founders don't just shut it down and start another business. So those are I think are a lot of the key shareholders agreement clauses. Now there were a few questions I just wanted to cover on some of these topics. Joseph had asked earlier, currently looking to sorry, it was more of a suggestion for a new webinar, future discussions on roles and responsibilities and exit strategies. Yeah, I covered some of that stuff, but that's not a bad suggestion. So Sonia's asked, how do you set up a company across 2 different regions? So let's just go back to the company structuring slide. I mentioned earlier, Sprintlaw has done this ourselves. Often you'll have, there's different ways to structure it, I guess is the short answer, but often you'll have a holding company that might be headquartered somewhere, and then you'll have operating companies in different regions. So for example, Sprintlaw has Sprintlaw Group, which is an Australian company. It has a subsidiary or Australian operating company called Sprintlaw Pty Ltd, and it has a UK company called Sprintlaw UK Limited, which is an English business. It's an English company. So the English company is set up to operate in England. It has an English bank account. It hires English employees. The Australian company has an Australian bank account, employs Australian employees, and both of them are owned by an Australian head company. That's the most common structure. You just set up new companies that are subsidiaries in different regions. There's other ways to do it, depending on tax considerations, exactly what you're doing in the other region. Sometimes you'll have another company that's just an independent company, and there's just a contract between it and your Australian company and so on. But yes, the most common way is to do it through that subsidiary type structure. And Sonia's also asked, so these questions you can talk to our lawyers about. Absolutely. If you're on the Sprintlaw membership, you can book a call through our platform, and to the extent that we can handle it in that sort of 30-minute call window, we're very happy to answer questions about any of the stuff that I'm discussing. So just on to other agreements, the shareholders agreement or partnership agreement is that key document that you want to put together, and you can see it's quite comprehensive in all the various topics that it covers. And if you get that document in place, you've really come a long way to sorting out from a legal perspective and securing the relationship that you have with your business partners and investors. Get the company structure right and that shareholders agreement right. Now, there's a few other documents that you often need to put in place if you've got the business partners. One is the employment agreement. If the people that are running the company and owning the company are also working in the company, they are not only directors and shareholders, but they might also be employees. And it's important, and a lot of founders don't do this because they think they're in a special category that they're not an employee. It's important to have an employment agreement between the co-founder who's working in the business or business partner working in the business and the company. That employment agreement is going to set out what they're getting paid, how their superannuation works, and what their roles and responsibilities are. And oftentimes in a shareholders agreement, you may have things like vesting that says for as long as this business partner works in the company, they will be able to hold on to their shares. But if they leave, they'll lose the right to their shares. Well, what does if they leave mean? Unless there's an employment relationship and an employment agreement that has a termination clause and a termination process, it can be very unclear as to how certain aspects of the shareholders agreement work. So you need to have the employment agreement in place. And again, to use the example of Sprintlaw, I'm a director, I'm a shareholder, and I'm also an employee. I've got an employment contract with Sprintlaw Pty Ltd. I have a shareholders agreement, and I'm sort of appointed as a director. So that is very similar to those of you running your own business and getting set up with business partners, a similar kind of structure that you want to set up. You really have these three roles. If you're doing all three things, you're an employee, you're a director, and you're a shareholder, and you need these employment agreements. So that's important to have. IP deeds can also be quite important. Employment agreements, if you have them, often have an IP section that says anything created by the founder or the employee will be owned by the company. And if you have them from sort of day one, then you're probably fine from an IP perspective. But it's also recommended that founders or important sort of owners of the business sign a separate document that makes it very clear that anything they've done in the past or in the future, maybe before we had proper employment agreements in place in the early days of the business, anything that was done in relation to this company is owned by the company. And again, that's important to make sure there's no disclarity about ideas that might have been discussed and recorded in the early days being taken away and used for another business operation. So again, they're simple documents, and usually we just encourage founders to sign one of them, and it will cover the past and the future and make sure that everything they do for the business is sort of owned by the business. And finally, a question we get a lot at the beginning is, when I set up my business, I put some money into the business, and I funded it, or maybe one business partner funded it more than the others. If that wasn't like an investment in the company, it was more just sort of startup capital, it may be that it's a loan that was made to the business, and maybe it was agreed that it would be paid back at some point. So again, it's important if money's being put in at the beginning to work out, what do we want to happen with this money? If one person's putting in more than the other, are they going to get paid back later on when the business has money or not? And again, we generally recommend having an actual agreement in place, just a really simple loan agreement that says, I, the business partner, am putting in this much into the business, and when the business hits this amount of revenue or profit, I'll begin to be paid back for the money I put in at the beginning. And that could help avoid disputes later where, people say, well, I put in all this money at the beginning and I never got paid back for it, particularly if they leave the business. So these are some other associated documents. They're fairly straightforward, but there are other things you may want to think about when you're getting your business set up with business partners. So that's all of the content. Hopefully people found that useful. I will answer now any questions people have in the Q&A. I can already see a few come through. Please feel free if you've got any specific questions of any kind. We've got about 10 more minutes, so I'm very happy to answer anything that comes through. So let me just go through these questions. Sony's asked, can Sprintlaw help with drafting IP deeds? Yeah, absolutely. Yeah, we could pretty much help with any document drafting request you may have in most areas of business law. So certainly we can do that, and we're quite experienced. What factors should co-founders think of when considering to be either an employee versus contractor, i.e. I provide services as a director to the company? Do I need an employment agreement, or should co-founders also be concerned about death or disability in the shareholders agreement? Let me deal with the second one first. yes, co-founders should be concerned about death or disability in the shareholders agreement, and it's another key clause section that I didn't really include here, but is a very important one. There is a section of the shareholders agreement that deals with that and what happens, and of course, it may be the case that depending on when that happens, the disabled or passed away co-founder would revert some of their shares automatically back to the company because maybe it was granted to them on the basis that they would be contributing for a period of time. It might be that their estate gets all of their shares or some combination of the two. But it is important to be clear about what happens to that stake. The default position, if there's nothing in there, is that it's just going to go to the estate, and the estate's going to have the ownership in the company. And of course, if you don't know the family of the business partner, you now have a whole bunch of different people involved in the company with different ownership stakes. So you can also have a compulsory buyback. Maybe it goes to the estate, but the company may be able to buy back the shares for a reasonable amount of money. There's many different ways to deal with that scenario, but again, it's a really important concept to be putting into the shareholders agreement. And then on the employee versus contractor decision, I think mostly when co-founders are setting up a company, if they're working in it, they would be considered by law to be an employee. And you can't really just do a contractor agreement and call it a director services agreement and say, I'm not an employee, I'm just a contractor. If you are working sort of full-time in the business, the sort of Fair Work laws kind of require that to be treated as an employee, and there's all these laws about sham contracting, et cetera, et cetera. Of course, if it's beginning as a side hustle, it's not making any money, it can't afford to pay wages, and you're just working on it part-time, yes, you may be considered to be a contractor for that early stage, and you could have a contractor agreement. If your business becomes a serious business, I would, though, usually recommend you set up an employment agreement and set yourself up properly as an employee, because it's a little bit grey to be sort of working in a business seriously and claiming you're a contractor when you're kind of setting it all up, if that makes sense. So it is a question we get a lot, and those early days can be a bit messy because maybe you can't afford payroll, and it's difficult to sort of pay employee wages and set yourself up properly as an employee. But as soon as you can get past that period and sort of be operating properly, we definitely recommend the employee option. Unless you truly are just, you set up the company, but you're not actually involved and you are a contractor, then you can have a contractor agreement. Rosa said, what if an early founder can put in time and effort but not money? I think that's a very common scenario that you've raised there, Rose. A lot of founders will not be putting any money into the business. And certainly when we started Sprintlaw, the two of us, I don't believe, had very much money because we were quite young. So we set up the company, and we gave ourselves at the founding, the 50-50 stake, the two founders, but we didn't put money into the business on day one, and we just put in labor and did a lot of the stuff ourselves. There's no requirement to put in money to receive equity when you set up the company. You can just say, the shares were issued for the nominal cost of $1 when you set up the company, and that's it. But oftentimes, there is some startup capital required, and founders will be putting money into the business. And so again, if money is being put in, you want to record it some way. How was that money put in? Was it a loan? Was it something else? And that's kind of what I meant by talking a little bit about those founder loans. But many companies are set up with the founders getting equity just for their sweat, if that makes sense. And there's no requirement that money's put in to receive the equity. Syed's asked, can shareholders agreements be amended, and how is this also defined in the agreement and the process around it? Yes, it absolutely is. And that's sort of what I was talking about in this termination section, Syed. So usually the process for amending a shareholders agreement is that you got to get the consent of 100% of the people. If we don't have that clause in there, then the majority can be tweaking it and really hurting the minority shareholders. If we say, we need majority approval to amend the shareholders agreement, it can be really risky for the minorities. That said, in bigger companies, as things get more sophisticated, you sometimes have, Class A shareholders and Class B shareholders, and the Class A shareholders can do things like make certain changes to the document without checking with the Class B shareholders. So it doesn't have to be done that way. but usually the document will set out a process. And again, for most small businesses, it's like this is locked in unless 100% of people agree to sort of change it. We had a question, how would you consider a founder who starts contributing 50-50, then isn't spending as much time in the business, starts working in another business for a period of time? Are these dealt with in the SHA? So yeah, look, that's a really common issue that emerges. The vesting schedule I mentioned is really meant to sort of cover that. And it's meant to say, XYZ people must work in the business, full time or at some level to maintain their shareholding. Now, in the most simple version of the vesting schedule, we don't differentiate between, it's kind of binary. It's like either you're in the company or you've left the company. The scenario you've talked about is they're still kind of in the company, they're just not putting in as much effort. And that's where things get a little fuzzy. But again, in the vesting schedules, what we often recommend is to make them as specific as possible. And you might say you have to put in this many hours per week, or you have to achieve these milestones. If it's a developer, for example, you've got to have released the app within the first 6 months. Otherwise, you're going to lose some of your equity. You can put a lot of that stuff in the vesting schedule, and that's kind of the mechanism for dealing with people that aren't putting in as much time. Now, like I said, oftentimes you'll have a period of time that you have this strict requirement for them to be working in the business or achieve these milestones, and at some point, they've locked it in, and then they own their shares either way. That's usually how it's dealt with. But absolutely, what you raise is an important consideration, and one that we see, for better or worse, happen a lot, and cause a lot of disputes between business partners. And again, you can also deal with it if you end up with something that the vesting process didn't cover. You can kind of go into dispute resolution, and oftentimes we see these issues just be resolved between the founders. One says, well, look, you weren't pulling your weight in the business. I don't think you should be entitled to as much as you were originally given. And can we agree to an amendment? And whilst it sounds counterintuitive, often the founder that's not putting in as much time will agree to an amendment, because if the other founder that's putting in more time, or the other founders are demotivated or frustrated by this issue, it doesn't help anyone. Everyone should want the pie to get bigger rather than to maintain their piece of the pie. And often in a mediation process, that can be sort of fleshed out. So there are ways to resolve this if you haven't handled it in the shareholders agreement. But of course, best practice is get it in the vesting schedule. Simi said, how does a free consultation work, and what does it include? You can book, I think we've got a link in the chat, or maybe we don't, but you can see on this screen now, we've got the QR code. You can scan that, you can book a free chat with one of our team members if you're not already a Sprintlaw member. If you are a Sprintlaw member, you have unlimited free consultations with our legal team. And so you can book a call through our platform at any time. And if you're having trouble accessing any of the links, just email our team at team@sprintlaw.com.au, and they can help you out. Just mention you attended the webinar. Jules asked, when's a JV preferred over a partnership agreement? I'm not sure whether you mean shareholders agreement or partnership agreement, as they're two slightly different things. But a joint venture, is sort of a bit of a different topic, but does overlap with some of what we discussed. Often a joint venture is used when two businesses are working together rather than two individuals are working on one enterprise together. I'll give you an example to help differentiate. Sprintlaw has from time to time considered introducing an accounting aspect, like a sprint accounting sort of thing. So we might partner with an accounting business, a different accounting brand, and together we'll operate some sort of joint legal accounting thing. That would be a joint venture. And we might set up a new company that does that in collaboration with this other business. And then, we have a shareholders agreement with that business where Sprintlaw was a shareholder and they were a shareholder, and it would be like a 50% owned subsidiary. It'd be a joint business that we're doing with another business. But it's not the same as the core business that we're doing in Sprintlaw. We also may choose to introduce accounting of our own accord, in which case we wouldn't do a joint venture and we would just do it within the business. So it's often used in those scenarios where businesses are collaborating. It can be done. Businesses can collaborate without a company or with a company. They can collaborate just by kind of working together. And lawyers would often call that an unincorporated joint venture. And then it's just a contract that says, the two of us will market this service together and do these things together. or they can do an incorporated joint venture where they actually set up a company that the business is jointly owned. But as you can see, it's quite a different sort of concept to the business partnership where you're working on one enterprise really together, if that makes sense. Jules said, how much is your membership? It is, I think, yeah, we answered that question, but $7.99 plus GST for 12 months. Yeah, there are some discounts if you are getting a service as well at the same time. Sides asked, if a majority shareholder is not an Australian citizen nor a resident, do they need to be present in person to set up the company in Australia? No is the answer to that question. Companies can be set up online. There's not a requirement that all the shareholders are Australian. There is a requirement that you've got at least a resident Australian director. And if you don't have a resident Australian director, you can't get a company set up in Australia. So someone needs to sort of live here and be listed as a director. But beyond that, you need to have, you can have investors from really anywhere in the world, and that's okay, even at the time of setup. And again, it can all be done online. Jules said, can you create a JV partnership for a launch? And what do you mean by a service, for example? I'm not quite sure what you mean by JV partnership for a launch. But if you wanted to trial something with another business and do something together, or you could have a joint venture agreement and launch it with that agreement for sure. And yeah, and what I mean by service, I guess, like, again, the joint venture is really intended for the scenarios where it's a joint venture between two unrelated parties who are coming together for a particular project. So yes, if you were coming together to do a one-off thing, you could do it as a joint venture, and it might not make sense to go into business together permanently. Whether you use a joint venture or you do it as a business is a decision that you can make, I suppose, depending on the commercial context. And the joint ventures are usually more light touch and more one-off in nature, and they just sort of say, hey, we're going to do this project together. Each of us will do this, one will do this, the other will do this, and here's how the money will flow. And it kind of ends there. You often don't need to deal with, drag along, tag along, and all those sorts of things because it's sort of project oriented or specific. But it can get more and more business-like if you really, going to be doing this for a long period of time. So I think, yeah, Julie, the example you gave is to promote a new business or service through an email list. Yes, you could do, if it was a one-off thing to just get started, you could do that through just a simple contract rather than setting up a whole new company. But if it becomes a more permanent thing, that might become more like you set up a company and do something together. Yeah. David said, any structure that can have protection benefits, but also if any loss incurred by the business can be used to reduce the investors or shareholders' personal income tax. That's a tax question, really. So probably better to ask an accountant about, because I'm not familiar with all the different scenarios of how losses can be treated with trusts and various sorts of things. There are some tax incentives. We have the ESIC scheme in Australia, which is like an early stage investment scheme for investors that invest in early stage companies that meet certain requirements. They can, I think irrespective of whether there's a profit or a loss, can claim some of their investments in early stage companies as a tax deduction or have some other tax benefit. So that's definitely something to look into. It's called ESIC, ESIC, so you can read about that online. In terms of whether you can, in the sense of like negative gearing, take losses from the business and use it against your personal income tax. Again, not aware of any straightforward way to do that, but again, I'm not really an accountant, so probably more of a tax question to check with someone. So we are about 5 minutes over. Those were some really good questions. Hopefully people have found this session useful, but sorry, ESIC, ESIC, ESIC. So I do, yeah. Hopefully people found the session useful. We will circulate the recording and look forward to seeing you all next month. All the best, everyone. I'll see you later.